All right, good afternoon. The court is going to take up the next case on the court's docket. This is cause number C200079CPS in the interest of baby boy Barrera, also known as Noah Barrera, and child. The case is set for resumption of a bench trial that commenced on July 21st, 2021. The hearing is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is caseworker Darcel Stewart, supervisor Isabella Reyes, and managing attorney Amy Lurs. The mother of the child is Lydia Barrera, and I'll confirm in a moment whether she is participating in the hearing. It's my understanding she has executed an affidavit of relinquishment of parental rights to the Texas Department of Family and Protective Services that was filed with the court on July 23rd, 2021. Tom Davidson is present as her attorney ad litem. Jason Bennett is the father of the child, and I'll confirm in a moment whether or not he is participating in the hearing. The court would take judicial notice of the court's file to the extent it reflects that Mr. Bennett has executed an affidavit of relinquishment of parental rights to the department that was filed with the court February 23rd, 2021. Nathan Butler is present as his attorney ad litem. Madeline Smith is the attorney and guardian ad litem for the child, and Ms. Smith is present in the courtroom. I also see on my screen Deborah Stever. Ma'am, could you advise the court your connection with the case, please?
I am the child's grandmother, and I have my husband with me, Barry Stever, and he is a child's grandfather.
His name is Barry Stever?
Yes.
Okay.
Thank you.
All right, thank you. All right, and the child is excused from participating in the hearing today. All right, just to confirm for the record, I did not see Ms. Barrera or Mr. Bennett participating in the hearing today. All right, Ms. Lurs, is the department ready to proceed with the trial?
Yes, Your Honor.
Okay, and Mr. Davidson, are you ready?
Yes, Your Honor.
Okay, and Mr. Butler? I'm sorry, Mr. Butler, I think you may be muted, or at least I'm not able to hear you. Your mic may be turned down.
I'm here, sir.
Mr. Butler, can you try again? I wasn't able to hear you. I'm still not able to hear you, Mr. Butler. I'll stand by for just a minute. I think he's having a connection issue. We'll try to resume in just a moment.
Your Honor, this is Amy. Did you already identify the LGL322DL person? And I missed it.
I understood that to be Mr. Stever, but if I'm mistaken about that, I'll send correction.
I wasn't sure who that was.
I'm sorry,
All
that is Jason Bennett. That's my son.
Okay.
Oh, that's Jason Bennett. Okay, that's Mr. Bennett. Thank you.
Thank you. I'm sorry. Thank you, Judge.
All right, we'll stand by for just a minute. We are back on the record in C200079CPS in the interest of baby boy Barrera. All parties and council previously present remain present. Mr. Butler, are you able to hear us now?
Can you hear me?
Yes, sir, I can. Okay.
Okay, good.
And I need to correct the record. I think when you were on earlier, I indicated Mr. Bennett was not present. He is in fact present in the courtroom as well.
Yes, Your Honor.
Okay, Mr. Butler, are you ready to proceed?
Yes, Your Honor.
Okay, and Ms. Smith, are you ready?
Yes, Your Honor.
Okay, Ms. Lurs, did you have any opening statement?
Your Honor, at the conclusion of this hearing, the department will be asking that you name the department as permanent managing conservator, that you continue the placement and approve the placement with the Stevers, and that you terminate the parent-child relationship for both parents based on their affidavit of voluntary relinquishment.
All right, thank you. Mr. Davidson, any opening from you?
Yes, Your Honor. We concur as the mother of the child with the department's view of this case, and we have executed a voluntary waiver of all parental rights, and we respectfully submit that to the court. Thank you.
Thank you. And Mr. Butler?
Yes, Your Honor. Same announcement. My clients executed the voluntary waiver, and we're submitting that to the court. My client did ask me to let the court know he understands that he had not reached a point where he is able to take care of his child at this point. He has been actively working toward achieving that goal, but he does understand that as a present, he still has some work to do, and he wanted me to let the court know it is his intention to continue that.
Okay, but he's ready, you're ready to go forward based on his affidavit of relinquishment on his behalf?
Yes, Your Honor.
Okay, thank you. All right, Ms. Smith, any opening?
Your Honor, I'm in agreement with the department's position.
All right, thank you. All right, if we're ready to proceed, I'm gonna ask Ms. Stewart and Mr. Bennett and Ms. Stever, if each of you would raise your right hands, please. Do each of you solemnly swear or affirm any testimony you may give before the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir. All right, thank you. All right, Ms. Lurs, if you're ready to proceed then.
Thank you, Your Honor. And for the record, Your Honor, the department mailed exhibits, petitioners exhibits 1 through 4 out to all the parties and to the court at the previous setting.
And as we go through those, I'm assuming we'll confirm whether or not they have them or any objections.
Thank you, Your Honor. Excuse me. And our first witness would be Ms. Stewart, Your Honor.
All right, thank you. You can go ahead and proceed.
Thank you, Your Honor. Ms. Stewart, would you state your name for the record?
Darcel Stewart,
And how are you employed, Ms. Stewart?
through the Department of Family and Protective Services. I am the caseworker assigned to this case.
Okay. And let's talk about the child. Where is this child placed?
Noah is currently placed with his grandmother, Miss Strever, in San Antonio.
And on the screen, it says Deborah Stever, Steever. Is that who you're talking about?
Yes, ma'am.
And is that the paternal grandparents?
You cut out a little bit. Is that the?
Paternal grandparents?
Yes, ma'am.
Okay. And this child goes by Noah, is that correct?
Yes, ma'am.
And how's the child doing in his placement?
He is doing great in his placement. He's thriving, happy, healthy. He seems safe and secure. He seems bonded with his grandparents.
Okay. Are they able to meet the needs of the child at this time?
Yes, ma'am.
Is this child old enough to verbalize where he'd like to live?
No, ma'am, he is not.
Are either of the parents at this time in a position, place in their life where they can meet the needs of this child?
At this time, no, they are not.
Does he have any specific needs that are being addressed, or is he growing into a healthy child?
He is growing into a healthy child. He did have some ECI services early on when he was placed with Miss Deborah, but I know that he is developing well at this time.
Do you believe the Stevers have a full understanding that in the future this child could have additional needs that could crop up due to the beginning he had in his life?
Yes, ma'am, I do believe she understands that and she is willing to address that and deal with that if the circumstances do arise.
Have the Stevers made progress on being licensed to be able to adopt this child?
Yes, ma'am, she has.
Okay. And you keep saying she, but she.
I'm sorry. Yes, her and her husband, correct.
Thank you, Mr. I'd like you to look at it, Petitioner's Exhibit 1. Is that a certified copy of the file marked Court of Continuing Exclusive Jurisdiction certificate?
1 second. Yes.
And it's listed as at the time it was filed was baby boy Barrera,
Yes, ma'am.
and date of birth of May 13, 2020.
Yes, ma'am.
And at the time of this child's birth, is that the name that was listed on the birth certificate?
At that time, yes, ma'am.
You want to move to Petitioner's Exhibit 1?
Objection.
No objection.
Petitioner exhibit number 1 is amended.
Now, Ms. Stewart, if you look at Petitioner's Exhibit number 2, is that the copy of the file of the order of establishing Mr. Bennett as the father of this child?
Yes, ma'am.
And that was filed in this court?
Yes, ma'am, that is correct.
You want to move to Petitioner's Exhibit number 2?
Any objection?
No objection.
No objection. No objection, Your Honor.
All right, no objection being heard, the petitioner exhibit number 2 is admitted.
And Ms. Stewart, if you look at Petitioner's Exhibit number 3, is that a file stamp copy of the affidavit of voluntary relinquishment of parental rights signed by Lydia Barrera?
Yes, ma'am.
And it's for the child Noah Barrera?
Yes, ma'am.
At the time of her signing this in July of 2021, is the department aware of any undue influence or promises made to get Ms. Barrera to sign that document?
No, ma'am, not that I am aware of.
Your Honor, I move to Petitioner's Exhibit number 3.
Any objection?
No objection.
No objection being heard, petitioner exhibit number 3 is amended.
And lastly, Ms. Stewart, I'd ask you to look at Petitioner's Exhibit number 4. Is that an affidavit of voluntary relinquishment of parental rights signed by Jason Bennett?
Yes, ma'am, that is correct.
And is that regarding the child that's before the court?
Yes, ma'am.
Was that also signed back in July of 2021?
Yes, ma'am.
And at the time that Mr. Bennett would have signed that, is the department aware of any undue influence or promises made to get him to sign that document?
No, ma'am, none that I am aware of.
Your Honor, I move to Petitioner's Exhibit number 4.
Is there any objection?
No objection.
No objection being heard, petitioner exhibit number 4 is admitted.
Ms. Stewart, is the department asking the court to terminate the parent-child relationship between Mr. Bennett and his child based on that affidavit of relinquishment?
Yes, ma'am, that is correct.
Is the department asking the court to terminate the parent-child relationship between Ms. Barrera and the child on her affidavit of relinquishment?
Yes, ma'am, that is correct as well.
Can you tell the court why the department believes this would be in the child's best interest?
Due to the fact that the baby is currently residing with his grandparents, Mr. and Mrs. Strever, he is thriving. They are capable of meeting his needs. Long-term, I mean, he's doing well. He's bonded with them. He's been there. That's normalcy for him.
Has Ms. Barrera made any progress on her services?
As has Miss Barrera, is that what you said?
Yes, ma'am.
No, ma'am.
Now, has Mr. Bennett begun making progress on his services?
Yes, ma'am. He has begun to make some progress on his services.
And why would the department believe at this time to terminate Mr. Bennett's rights versus continuing to provide services to him?
At this time, just due to the still lack of progress with Mr. Bennett's services, he is trying to make progress, but at this time, he would still have quite a ways to go in order to achieve completion of those services and then be able to maintain stable housing and things like that that NOAA would require. So it would be in NOAA's best interest to go ahead and stay where he is.
And we've already talked about the Stevers are making progress on getting licensed to adopt. If the court grants termination, are you asking the department be named managing conservator and that they be allowed to adopt at a later date?
Yes, ma'am.
You're asking the court to approve the current placement of the child with the Stevers?
Yes, ma'am.
And have you or someone from the department talked to the Stevers about adoption already?
Yes, ma'am.
And if the court grants this, the requested relief, you're still asking that Miss Madeline Smith stay on as the ad litem for the child, is that right?
Yes, ma'am.
You and I pass the witness.
Mr. Davidson, did you have any questions? Okay, no question being heard. Mr. Butler, do you have any questions?
No, Your Honor.
Ms. Smith, did you have any questions?
Your Honor.
No? Okay, thank you. All right, Ms. Lewis, did you have any other witness you want to call?
No, Your Honor.
Okay, department's resting. Mr. Butler, did you have any witness you want to call?
We rest, Your Honor.
And Mr. Davis, any witnesses? No witness? Okay, thank you. Ms. Smith, did you have any witness you want to call?
No, Your Honor.
All right, all parties in rest and close.
Yes.
Yes, Your Honor.
All right, any closing from anyone?
No, Your Honor.
Okay,
No,
Ms.
Your
Smith, any recommendation other than what you've already done? My understanding you're in agreement with the department's request.
Correct, Your Honor.
It's being in best interest of the child. Okay, thank you.
Your Honor,
I'm sorry.
Your Honor. Hi, just wondering, what is the next step for us?
Well, Ms. Stever, you'll need to discuss that with the department. What the department is requesting right now is a court order that would, if granted, would terminate the parent's parental rights. It would continue or appoint the department as managing conservator of the child. The child would remain in your care under the department's supervision, and then they would be working with you towards a possible adoption of the child by you both, you and your husband, I guess, at a later date. That's what I understood their testimony to be.
Okay, thank you.
All right, thank you. All right, the court, having heard the evidence presented and after taking additional notice of the court's file and the recommendations of the attorney and guardian ad litem, is going to enter in the following findings and make the following findings and the following orders under Chapter 201 of the Texas Family Code. Court finds that a request for invocation of the court of continuing jurisdiction has been made as required by law, and no other court has continuing exclusive jurisdiction. And this court has jurisdiction over this action. Court finds that all parties entitled to notice have been notified. The court finds that any presumption that either of the respondent parents should be appointed as a managing conservator or as a possessory conservator of the child is rebutted. That it would not be in the best interest of the child to appoint either of them as a managing conservator or a possessing conservator of the child, as it would significantly impair the child's physical health and emotional development. Court finds by clear and convincing evidence as to each of the respondent parents that they have both knowingly and voluntarily executed after the suit was filed affidavits of voluntary relinquishment of parental rights to the Texas Department of Family and Protective Services, relinquishing their parental rights to the children the subject of the, or the child the subject of this suit. And the court further finds as to each respondent parent by clear and convincing evidence that termination of the respondent parent's parental rights to the child would be in the best interest of the child. Court finds by clear and convincing evidence that the court's findings under section 161.001B Texas Family Code and the order of termination of the respondent's parental rights is not based on evidence precluded from consideration by the court under section 161.001C Texas Family Code. Court finds it would not be in the best interest of the child to appoint a relative or other person as permanent managing conservator of the child. It would be in the best interest of the child to appoint the department as permanent managing conservator of the child and to continue the child in their current placement pending further order of court. Court finds by clear and convincing evidence that the following orders should be entered. The court hereby orders that the parent-child relationship between the respondent mother and the respondent father and the child is terminated. The department is appointed as permanent managing conservator of the child with all the rights and duties of a non-parent permanent managing conservator under applicable law. The current placement of the child is approved pending further order of the court. The court will discharge with the court's thanks Mr. Davidson and Mr. Butler 31 days after entry with a final order by the court reflecting the findings and orders announced by the court today. The court will continue Ms. Smith as attorney and guardian ad litem for the child, and I'm going to set a permanency hearing after final order on November 1st, 2021 at 9:45 a.m. Court gives notice to parties and counsel of the right to appeal the court's findings and orders pursuant to section 263.405 Texas Family Code and of the right to request a de novo hearing before the referring district court pursuant to section 201.015 Texas Family Code. Court gives notice that an appeal in a suit which termination of the parent-child relationship is sought is governed by the procedures for accelerated appeals in civil cases under the Texas Rules of Appellate Procedure, and the failure to follow the Texas Rules of Appellate Procedure may result in a dismissal of the appeal. With that, we'll be adjourned. I'm going to ask the department to prepare and submit an order of termination reflecting the court's findings and orders. Thank you again for all
Yes, Your Honor.
the efforts of the parties involved.